Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law. Today's guests are June Carbone, Robina Chair in Law, Science, and Technology at Minnesota Law School, and Rachel Rebouché, the Dean, and Peter Liakoris, Professor of Law. Did I get that right, Rachel?
You did. Thank you.
Okay, excellent. Well, I'm so happy to have you both on today because you're both writing in such very interesting topics. I know that you had the 7th edition of Family Law come out with Aspen Publishing in 2023, the book that you both write, co-author with Leslie Harris. And first, we're 7 editions in. I think, June, you were on the book first. Why don't you just highlight a little bit about how over those 7 editions, family law has changed?
Oh, wow. All kinds of ways. So the first, every time we do the book, we spend more time on people who aren't married. Marriage is no longer the only way or even the preferred way to start a family. The idea of what a family is changed dramatically. Certainly the incorporation of same-sex couples. I mean, there were years where every time we teach family law, even from the same edition of the book, there would be a half dozen new developments. That's slowed down, but hasn't stopped. And the current issue is reconciling same-sex married couples, different sex married couples, and unmarried couples from all kinds of walks of life. The third, the family has become a marker class very, very dramatically. I think the legal academy has been slower to recognize that than other areas of the academy, but I will say my first book of any kind came out in 2000, and I had these charts showing how family form corresponded very closely with the income. At that time, it was new. I went to a conference. I had drafts of the book. I had pieces of paper. I circulated around the room, and people looked at it. This is one of Martha Feynman's workshops in New York, and said, "Oh, wow." And I would say now we have that as something we're very conscious of in the casebook.
So when you say that class is very tied to family form, can you tell those of us who don't study these things what that looks like in reality? The wealthier people are doing what versus those who find themselves in poverty when you're looking at the family form?
We start with marriage. 40% of births in the US are non-marital. And when you look at what predicts, so if you look at college graduate couples, the percentage of births out of marriage is under 10%, has stayed under 10%, and has dropped in the last few years. When you look at people who don't go to college, not just has the marital birth rate exploded, but if you look at divorce rates, for college graduates, divorce rates started to level off and then drop in the 90s. By the time you get into 2010, they're about the same as they were in 1965 before no-fault divorce. But divorce rates for everybody else has gone up. So if you look at the percentage of children being raised by two parents to whom they're related, two legal parents, for college graduates, the number has stayed above 90%. For non-college grads, it's continued to increase and is something now like 2/3. 2/3 of children whose parents don't go to college will live in a single parent family at some point during their childhoods. This is a huge gap.
And then I'm following from that, those single parent households are more likely to be at a lower socioeconomic status.
Right. So you have all kinds of legal implications. First, I like to point out marriage is a really bad deal if the same person is both the primary caretaker and has a more reliable income. It doesn't have to be the higher income, just the more reliable income, because breakups occur at the low point, generally in the man's earning trajectory. Not because women don't kick men out because they don't have money. They kick men out because of the behavior associated with loss of a job, or running up the bills, or treating the guys at the bar when there's not enough money to feed the children. These are the kind of issues that attend a much more insecure part of the country. So all those things go into it.
Thank you. So Rachel, when did you join the book and what topics do you focus on and have added expertise to?
Well, so I joined not this edition, but the edition before. And I have to say say that June's thinking and scholarship and mentorship, what has made a difference in my life as a scholar. I mean, she has really been someone that has mentored me. Those of you who are listening that don't know June Carbone, she is not just unbelievable intellectual, but she is a really good person. And I joined with her mentorship. And what I added, I've spent a lot of time thinking about contracts and teaching 1L contracts. And I took over the contracts chapter, spent a lot of time thinking about surrogacy contracts, but also the way in which collaborative divorce has changed divorce. But I think probably where I've spent a lot of my time is on reproductive rights. I write a lot about abortion law, and there's been a lot happening in that space. So the new edition is not only, as June describes, cognizant of the changing dynamics of family law, which I really think is a bellwether of social justice in this country, but keeps up to date with not just changing family forms, but changing constitutional decisions about reproductive rights and the various decisions that are shaping our country.
So no small contribution there. There's been a lot in reproductive rights. And I wonder if you all could speak to the consequences of the Dobbs decision on not only abortion rights, but also marriage equality, parent rights, and parentage. There have been some other results that perhaps were unexpected.
Yeah.
And let me say, Rachel has been phenomenal on this issue. Her work has gotten an extraordinary amount of attention, and it's laid out the roadmap for what's likely to happen next. I was editing last night another piece I'm working on, and looking at something Rachel wrote about a year ago and thinking, oh yeah, that's exactly what's happened. So take it, Rachel.
Well, we have a mutual appreciation society, but I'm going to say again that I owe everything to June. So.
All right, you both have convinced me of how amazing and awesome each of you are.
Well, and thank you, Patty. I mean, because you pointed out that, look, revising a casebook is not fun. It's not fun, but it's as fun it could possibly be with someone like June and someone like Leslie. That's all I'll say.
All right, excellent. So Dobbs, what have the consequences? I mean, you know, we could spend hours on this, but what are some of the consequences you can share of the Dobbs decision beyond abortion rights? And what's the predictive value of the decision? Because it seems to me Rachel may be able to speak to that.
So I'll start first. Yeah, I mean, here's the thing, is that we, when revising the casebook, spend a lot of time on the concurrences, because you have a concurrence that says this is not going to change anything. You have a majority opinion that says substantive due process rights are here to stay. And Justice Alito, writing for the majority, says this is just about abortion. It's only about abortion. But then, of course, you have Justice Thomas say, let's get rid of the whole thing. And that's a really interesting fracture for family law people on the Supreme Court, because I bet that the people who voted for Dobbs do not think that there is not a constitutionally protected rights parent. I do not believe that Kavanaugh or Barrett or Gorsuch or Alito or the rest, maybe Thomas, but maybe not, do not believe that Meyer and Yoder and the cases that we highlight in the casebook, that they were wrongly decided because they helped cement this idea that the parents older than the Bill of Rights have a right to the care, custody, and control, as O'Connor wrote, of their children. And I think that's really interesting given the diversity of family forms that we have today. And I think that it might put at odds social movements that want to protect family rights and want to protect personal autonomy to medical care. It may not happen, but Dobbs could put us on a collision course in that way.
Yeah.
Can you expand on that, June? What would that look like?
Well, let's run through it. So the first thing I often do with my classes is to say, Justice Thomas is the one expressing in print consistently skepticism about substantive due process, which is the source of parental rights in constitutional decision making. But if you read Troxel, a grandparent visitation case, Thomas is the most extreme justice on the court, saying, I'm not going to weigh in on substantive due process, but if parents have rights, they're subject to strict scrutiny. And so I asked my class to invent, okay, if we're going to get rid of substantive due process, where are parental rights coming from? Now, Justice Thomas is notable, not so much in his opinions, but in his non-judicial writings for his exploration of natural rights theory. And if you go back to natural rights at the time the Constitution was adopted, to John Locke, for example, is a classic natural rights theorist, labor theory of value, rights to property. But in the context of that worldview, the family precedes the state, and parental rights are close to absolute, with statutes on the books at the time that the Constitution was adopted, indicating that parents, or more specifically the father, had the right to kill a child in certain circumstances. And so the entire concept of parental rights predates the Constitution, and those who are most inclined to take a conservative and a historical worldview tend to be the ones who believe in parental rights the most, just not within the framework where the Supreme Court has found parental rights historically. So that itself is just a fascinating question. You start thinking about decision making with respect to trans children and to other kinds of medical decision making. I mean, this just sets up an enormous exploration, but it also revisits the question of who the parents are.
And also, let's remember that the time that Justice Thomas is hearkening back to, idealized community of parental rights, was a time in which people were enslaved and had no parental rights over their children. They had no right to keep their children. They had them sold off. I mean, Michelle Goodwin's brilliant about this. And it just, I don't mean to be incendiary, but it's really awful to pretend as if parental rights have been this torchbearer of liberty, which they could be, but in which we denied a segment of our population all of their parental rights.
Well, they were a torchbearer of liberty for the white people, right?
Right.
For the elite. That's so, yes, I can see that becomes extraordinarily difficult.
I do want to raise the current issue. So, at the time, indeed, before the last edition of the casebook, I would have said, okay, we have Obergefell, which is also rooted in substantive due process, though could also be rooted in equal protection. And one of the express purposes of Obergefell was to provide more protection for children to have continuing relationships with the adults raising them. And almost immediately after Obergefell guaranteed marriage equality, you have a case Pavin, in which what happened is you have a same-sex couple, two women, they're married, they use artificial insemination by donor, and the state refuses to give them a birth certificate acknowledging the two married women as parents. And the Supreme Court says, can't do it. If you would have recognized a husband who is not biologically related to the child under the statute, you have to recognize a wife who is doing exactly the same thing as the husband, consenting to the insemination of her spouse. And we've been kind of waiting one step at a time. The lower courts after Pavin have insisted on recognition of same-sex married couples as jointly parents. And then one of the cases we have in the new edition is Idaho. And Idaho is just so I've been waiting for a case. How are conservative states going to buck this? Because they want to. And some states like Indiana have tried. And I talked to somebody in the Attorney General's office in Indiana and looked at their statute and told them, no way. You have the statute of all the ones I've seen in the country most supportive of same-sex married couples being able to get recognition. And that's what the courts held.
Good for you for pointing that out to them.
But then along comes Idaho. And Idaho, in a really extraordinary case, refuses to recognize a same-sex spouse who signed consent forms, performed the insemination of her spouse personally. The spouse added her partner, her wife, to the birth certificate in the hospital. And the Supreme Court of Idaho said, no, we're not going to recognize her as a mother. She has no standing to seek custodial rights or a continued relationship with this child, even though her spouse had been charged with domestic violence against her. And the way the Idaho Supreme Court decided this case, as a practical matter, would invalidate every case of artificial insemination by donor in the state. There would be no men either recognized as the fathers of their children, the children they raised, the children born to their wives, if this decision were to apply. It's extraordinary. And I think we're going to see more cases like that.
That is
after
extraordinary.
Dobbs.
So you've pointed out some of the issues post Dobbs, certainly, and the class warfare that can occur as a result of the form of the family. But when we were talking earlier, you mentioned how family law intersects so many areas of the law, so many areas beyond what we might normally think of. And so I wonder if you can expand on that.
This is what I love about family law. And this is the unknown gem about teaching it. You have to learn about criminal law. You have to learn about constitutional law. You have to learn about contract law. You have to learn about trust and estates. You have to learn about all areas of law because all those areas touch family law. And when Pennsylvania passed the new bar exam, it was going to leave out family law, and people revolted. How can you leave out family law? It's the thing that people want to know the most about. So in my work, I think a lot about the ways in which family law is not about divorce or custody or statute. It's about negotiation. It's about contracts. It's about trying to get to a place of yes. But that's my purge. Someone like Naomi Kahn, June's co-author and good friend, my good friend, thinks about estate tax, thinks about what's going to happen when your beloved family member dies. We have a chapter in our book about bankruptcy tax and the other, and I fear it's not taught enough because we are not bankruptcy tax experts, but it's absolutely vital to family law. We just covered a portion of family law that has been excluded, I think, unfairly, reproduction. And we have focused on the elimination of a right to have an abortion, but June has been a torchbearer for the right to assisted reproduction. I've written a lot about surrogacy contracts, and the world is changing. So family law is really dynamic. And if you want to have a multidisciplinary practice, go into family law.
And yes, and I want to say one of the classes I'm proudest of that ties together some things you don't ordinarily think of as the core of family law, but they are, is police violence.
Oh, yeah.
I live in Minneapolis. We have the case of George Floyd. I think every professor in the city has felt compelled to address the racial inequalities in the city. But one of the cases in our textbook is Turner versus Rogers, a U.S. Supreme Court decision on child support enforcement. And in 2015, there's a man, Walter Scott, South Carolina, who was shot in the back while running away from the police after a routine traffic stop for something like a broken taillight. And why did he run away? Because he had unpaid child support bills, and he had a warrant out, or he feared he had a warrant for his arrest for unpaid child support. He describes, when you look at his life, he lost the best job he ever had because he spent time in jail for unpaid child support. He had children from multiple families, and he couldn't support all of them. And he was terrified of being sent back to jail because of a routine traffic stop. And the police officer who shot him was convicted of murder, manslaughter, and sentenced to 20 years in jail. So that's unusual too. But what I give the students is a description of child support enforcement in South Carolina, where the murder of Walter Scott occurred. And then I give them the Turner decision. And the Turner decision, the facts in the Turner decision, they fit hand in glove the facts that describe what is taking place in South Carolina, where you have low-income men who are routinely asked to pay more than they can afford, where it is the state often bringing the enforcement action against them. When middle-class men are in that position, they typically trade. They seek a higher percentage of the child's time in custodial rights, and then that reduces the amount of child support they owe. And since it's typically the other parent who brings the action, they can also negotiate. So if he can't pay today, but he can pay tomorrow, they can negotiate this. When you're talking about low-income men in actions initiated by the state, they are more likely to be unable to pay, unable to get modifications that reflect loss of income, unable to bargain about custodial rights, unable to reach deals with the other parent because it's the state that controls litigation, and then subject to imprisonment for failure to pay in a way that is the modern day debtor's prison. And there's a dissent in that case by Justice Thomas calling the men deadbeats and saying, how do we know they can't pay? They might have some hidden job we don't know about that's not in the record. The easiest way to get somebody to pay is put them in jail. Then whatever money they have, they come up with, and that's better for the children than if they don't pay. And that case, in terms of capturing the traps for low-income folks, with the majority of money collected in state-initiated cases often going to the state and not to the custodial parent, these cases illustrate the face of poverty, the traps that are there for low-income parents, the way in which even the same rules, child support guidelines, have an entirely different impact on low-income parents than they do on middle-class parents. I think that class for me is one of the ways of tying a Supreme Court decision, the reality of child support enforcement on a routine basis, the difference in custodial rights, and the role of race and class in a way that just ties together a lot of different things you don't ordinarily see in the typical law school classroom.
You are a very compelling storyteller and such good lessons. I'd like to take a class with you. I'm going to ask you the provocative questions you mentioned we were preparing. What's happening to men and what's happening to sex? I have to say, that's the first time in 130 episodes of doing a legal podcast that I've ever said sex. Now I've said it twice.
I do have an article coming out on this with Claire Huntington, Rachel.
I will just chip in very quickly to say that June's description, and I'm just going to put a shameless plug for the casebook right here, and then we can talk about what happens to men. We have been more attuned to the ebbs and flows of family law as people's justice in a way that I hope the current edition reflects. I think it does, but that we take as our mission that we are going to not just teach students doctrine, but teach them why family law matters and why it's changing. And that's why you should subscribe to our casebook.
Well, there's a reason to buy it right there.
There you go. If there's a book with June Carbone's name on it, you should buy it right now, right away, pre-order it, get it done, because no, it's true. She has the right read of what's happening in this country. And my God, she has been prescient about everything that's happening in terms of the divide between the haves and have-nots. If I may, June, because we're friends, she knows what she's talking about. Like, she does not come from an ivory tower. She's incredibly accomplished, but she knows, she understands because she cares.
Well, thank you. It's very hard to follow up on that. So I'm giving you my grand prediction. When you look at demographics, I am a co-editor of the International Survey of Family Law, and I'm getting articles from scholars in China about the results of demographic implosion. The white one-child policy succeeded in reducing population growth in China, but now they've lifted it. Now they're encouraging parents to have 3 children, and Chinese women aren't going there. When you look at the US, and whether it's a good thing or a bad thing, people differ. But for a long time, the US was reproduction rate 2.1, just above replacement. A lot of people thought that was ideal. And it was also due in large part to Latino immigration. Why did the US have a higher birth rate than much of the rest of the world? Because we had lots of Latinas having babies, which upset a certain part of the population. But since the financial crisis, we have had a plunge in births. We now look like Northern Europe. We're no longer ahead of the rest of the developed world. When you look specifically at Latina fertility in the wake of the financial crisis, it fell in half in the key age groups, late teens, early 20s. You saw a plunge in birth rates, partly because there's less immigration. Immigration from Mexico peaked in 2000 and has declined steadily since. It was net negative in the period right after the financial crisis, more people going back to Mexico than coming. But what you look now, and the crisis we have on the border is not a large number of new immigrants. It's refugees who stand in line at the border as opposed to sneaking in, and standing in line creates long lines. But the decline in immigration that started during the Obama administration has meant that the overall birth rate is dramatically lower. If you then add to that the greater availability of contraception, which started again before adoption of the Affordable Care Act, but was a priority in the Affordable Care Act, what you're seeing are dramatically fewer births. And if you look at the period from the early 90s to 2014, you see that for wealthy women, fertility, unintended pregnancies fell in half and increased by 50% during the same time period for the poorest women. All those trends have been reversed. It is the poorest women who have experienced the largest decline in unintended fertility. That means they now have birth control and didn't used to. And when you talk to young people generally, the number of people who say they're not going to have children at all have increased. But fertility has not fallen for college graduates in their 30s. This is a growth area. So what does that mean for family law? This is one of the untold stories, not out there yet. First of all, low fertility is a drag on the economy. You're not going to see as much economic growth if you have fertility well below replacement. Secondly, who are you going to leave up the property you have to? And who's going to take care of old people? For China, that does not have a social safety net or Social Security or the supports we have, this is a huge issue. But in the US, with the combination, Naomi and Claire and Buffy Scott at Columbia, I have an article, The 100-Year Life and the Implications for Family Law. What you're seeing is a lot more families without children, who never planned to have children or whose children have grown up. And what families look like in that context becomes radically different. The law is different. The societal implications are different. And then you get to men. So if you combine not having kids with not getting married, you find out things like working class men who are between the ages of 19 and 23 report the highest number of partners of almost any group in society. But when they get to be in their 40s, they're more likely to report not having children, not currently in a relationship, and not getting so much sex either, compared to when they were 20. And that's a radicalizing effect. I mean, that's a destabilizing effect in any society. And where you see it in family law is when you look at custodial patterns. So shared custody is now the norm. You get divorced, there's no judge who's going to grant a divorce without asking, who's the father? How many kids are born into this relationship, and giving both parents custodial rights if they want them. For unmarried couples, when the breakup occurs, typically women initiate most of the breakups, married or unmarried. They just kick the guy out. He wants custodial rights. He has to go to court. He doesn't go to court. For one thing, he might be hit with unpaid child support payments. And that means that low-income fathers are less likely to see their children. They're less likely to have formal rights. But increasingly, a higher percentage of low-income men aren't in family relationships at all. And that has huge implications for any society.
Wow. Well, thank you for explaining the answers to the provocative questions. I have a feeling we could talk for hours more about it. I want to mention, before we go to our final question, that despite being Dean of Temple University Beasley School of Law since 2021, Rachel is still publishing, hasn't slowed down, because her area of scholarship certainly hasn't slowed down in the area of reproductive rights and other family law issues. And that, June, you have a forthcoming book that will be published regarding how the workforce and priorities have changed, particularly for women. And I'm going to have you on for another episode to talk about that because that is
Good.
fascinating.
Anytime.
And before we conclude, I'd like to ask each of you what your predictions are for the future of legal education in the coming decade.
We're going to face some lean times. The acceptance rate for undergrads is down by 30% across lots of states, Pennsylvania included. And so that means in 5 years, the law school rate will be down too. And we need to be thinking about what we do to make our education relevant to the people who are entering it. And it may mean thinking about our tuition. So I again apologize. I'll brag about Temple. We are accessible as a plan, and we've got to be thinking about the next generation of lawyers, who they are and where they're applying. So other than that, family law, June didn't get a chance to talk about some of the changes that have happened for adoption and the various ways in which couples are having children be part of their families. But I think that I am grateful that there's an interest in family law, and I'm grateful for this time here today.
Thank you. June, did you want to add anything to the predictions for the future of legal education?
Sure. First, you have to see it. There's been a war on higher education.
Yeah.
And here in Minnesota, we feel it. It dates back decades. Missouri, where I taught previously, was worse. In fact, when I moved to Missouri, people said to me, Missouri doesn't believe in taxes. And that means we are starved in good times and cut to the bone in bad times. And they have tuition lower than Temple's. And so what has happened at schools like Minnesota, we draw from a national audience, but our tuition is like airline tickets. Everybody pays a different price. It's marginal cost pricing. When I was last looked, I think students paid 53% of the stated price. But that means if you have very wealthy parents, you might pay full price to go to a more prestigious school. If you want to practice family law, you should go to the school that gives you the most money in the region you want to practice. Makes no sense to pay a lot of money to go to an elite school. But I also see a change in the nature of the students. So there was a time when students came to law school because they wanted to make money. Then they stopped coming to law school. And then since 2016, I see a much higher percentage of the class coming back to law school because they want to change the world. And that group needs not to emerge from law school burdened by debt, because they want to go work for social justice movements. They want to do the kind of law that helps people. And the students, I see a number of students who come from pretty non-elite backgrounds, and they go to the school that offers them the largest scholarship. And that's what we're doing. I mean, as I said, it's a huge range in how much people pay, but the assault on higher education in general and law schools in particular by state legislatures is an ideological fight that has been waged for decades, and we're now reaping the benefits, and they will make the United States a poorer country.
And just a quick shout out, Josh Shapiro just announced a 15% bump for public community colleges and schools like Temple. So I'm 100% in agreement with June, but I got to give a shout out to my governor, who is putting the money where his mouth is.
And my prediction is free community college for everybody will increase marriage rates.
Yeah, I agree.
Okay, well, thank you both. June Carbone, the Rebouché Chair in Law, Science, and Technology at Minnesota Law, and Rachel Rebouché, the Dean at Temple University Beasley School of Law, and congratulations on the 7th edition of Aspen Publishing's Family Law book, written by both of you and Leslie Harris. For those of you who are listening, if you'd like to listen to other thought leaders in legal education, you can find additional episodes on Aspen Leading Edge's podcast and other places where you find your favorite podcasts. Thank you, ladies.
Thank you.
Thank you. You were terrific.
Thanks.
Yeah.